Mr. McLeod,
Contempt for what?
Mr. McLeod, two things are going to happen. You're going to answer my question, or you're going to jail for summary contempt for not complying with the court's request. Do you, Mr. McLeod, understand that the maximum penalty for the charge against you is 3 years in prison and or $1,000 fine?
I don't understand the charges.
Mr. McLeod is in contempt court taken into custody.
Really? That's it.
From beginning to end, this hearing is complete disorder. Mr. McLeod is facing charges for allegedly assaulting a police officer. Instead of focusing on the accusation, he argues that the court has no power over him. He uses the usual sovereign citizen claims, interrupts repeatedly, raises his voice, and throws around legal terms that don't actually apply. Each time, the judge firmly corrects him. As the tension builds, things get heated. In the end, the judge decides there's no choice but to have him held in a jail cell for the night. Watching it unfold is both frustrating and oddly amusing.
You understand your right to a lawyer, including a court-appointed lawyer?
I understand that.
Okay. And do you wish to represent yourself instead of having an attorney?
Yeah, I'm here by special appearance, and I will be representing myself.
Okay. I'm required by law before I accept that waiver to do a couple things. One, advise you of the maximum penalties that you could face for the charges that you're in my court for. Resisting, obstructing conservation officers is a high court misdemeanor punishable by up to 2 years in prison and or $1,000 fine. There's a habitual offender second notice that's been filed by the prosecutor, which would make that a felony punishable by up to 3 years and or $1,000 fine. And marine safety operating while intoxicated is a misdemeanor punishable by up to 93 days and or $100 to $500 fine. Do you understand the maximum penalty for the charges against you?
Well, I don't even really understand why I'm here, honestly.
Mr. McLeod seems extremely confident in arguments that clearly aren't helping him, and the court systematically shuts them down. If you enjoy courtroom breakdowns like this, be sure to show your support and follow along. One thing that stands out is how calm the judge remains. Despite the constant interruptions, he gives Mr. McLeod multiple chances to respond properly. His patience is noticeable.
Okay. Well, that's fine. Do you understand the maximum penalty that I just explained to you?
No.
Hold on. I can't let you represent yourself until I establish a couple things.
Well, I need to establish a couple things too, honestly.
Hold on. Well, I can't let you represent yourself until I establish a couple things, or I'm going to be in trouble. Okay. Do you understand that the maximum penalty that you could face for the charges that you're here for is up to 3 years in prison and or $1,000 fine?
I don't understand the nature and cause of the action against me. So
what is it that you don't understand? Do you not understand how long 3 years is, or how much the fine is that I've articulated? Can you tell me what it is you don't understand?
The nature and cause of the action against me because we don't establish jurisdiction.
That's not what I'm asking you right now. Well, I'll let you place whatever objections you want on the record, Mr. McLeod. I promise you that. Okay. Can we just go one step at a time? So do you understand the maximum penalty that you could face if you're convicted as charged? 3 years in prison or $1,000 fine?
Well, I have another question because the statutory jurisdiction doesn't exist under the Constitution. So in order for me to defend myself, could you please tell me where the published rules of conduct are for criminal statutory jurisdiction, or where I can find the nature and cause of this jurisdiction, or how this information exists?
No, I don't even understand what you're asking.
So you're saying this is a statutory jurisdiction under what? The statutes of Michigan, correct?
Mr. McLeod, I've told you what my jurisdiction is.
General jurisdiction.
The people of the state of Michigan voted to convene a constitutional convention in 1961.
Sure.
There was a constitutional convention in 1961 and 1962. They proposed a state constitution. The voters of the state of Michigan ratified that in 1963. Article 6 establishes the judicial power. And the circuit court is a court under that judicial power of Article 6 of the state constitution. And so you're here in my court. I have subject matter jurisdiction over those crimes. I have personal jurisdiction over you because you've been alleged to have committed them in our county. That's my jurisdiction. So Mr. McLeod, you want to represent yourself? Do you understand the maximum penalty that you could face of 3 years in prison and or $1,000 fine?
One second.
I can see why his attorney withdrew. Oh, shit.
Hang on, someone in the prosecutor's office is not muted. I'm going to remove you from the meeting at this time.
Oh,
Prosecutor's office is generally allowed to attend to observe. They've participated. I'm removing them from the hearing.
Especially as Mr. Mloud pretends not to understand basic legal questions. It makes you wonder, is he truly confused, or is this a strategy to avoid responsibility? There's also a moment in the courtroom that feels completely unfiltered. You can sense what everyone is thinking. It even explains why his attorney stepped away from the case. Mr. Mloud sits there flipping through a stack of papers, searching for some supposed rule that will instantly clear him. He appears convinced he has discovered a hidden loophole, while everyone else in the room already knows how it will end. Instead of helping himself, he keeps pushing arguments that only make things worse. It raises a bigger question about people who rely on these types of legal theories. Do they really expect a judge to suddenly agree and dismiss the case? Courts have consistently rejected these claims for decades.
Mr. Mloud, do you understand the maximum penalty that you could face?
1 second. Okay, so when enforcement of mere statutes, judges of all courts do not act judicially and are thus are not protected and qualified by limited immunity. That's Owen versus the city. I just want to state a few things for the record since you're claiming this is a jurisdiction under statutory law.
Hang on. Mr. Mloud, can we back it? Look at me for a second. Can we talk here?
I challenged subject matter jurisdiction and nothing can go forward until that's addressed. You're saying
I did address it and I denied your objection. I have subject matter jurisdiction.
Exists under the Constitution.
Your objection is noted. So, Mr. Mloud, do you understand? Let me explain to you.
Sure.
Sometimes, as I said, people might want to represent themselves, but let's say they have limited intellectual capacity and they don't understand what's going on.
Judges are required to follow established law, not personal interpretations or internet theories. Another key point is that Mr. Mloud had the right to legal counsel under the Sixth Amendment to the United States Constitution. If someone cannot afford an attorney, one can be appointed. Yet he chose to represent himself and argue points that carry no weight in court. At the start, the judge explains things slowly and clearly.
I have to establish that they know what's going on before I can allow them to represent themselves. I'm required to establish, do you comprehend, do you know the maximum penalty that you could face if you're convicted as a result of this charge? 3 years in prison or $1,000 fine. Do you understand that, Mr. Mloud?
So I'd like to state for the record that
Mr. Mloud, stop.
the court can be
Stop, Mr. Mloud. If you don't understand it, I'm going to revoke your right to represent yourself and have an attorney represent you because I can't establish that you know what you're doing. So do you know the maximum penalty that you would face?
Your Honor, I've challenged this court's jurisdiction. You haven't established it yet. You said you have a statutory jurisdiction which doesn't exist under the Constitution. I'm trying to figure out where I stand with this. So I can't answer any of your questions until you answer some of mine.
That's not how it works. Are you refusing to answer my question?
No, I'm
Then answer it. Do you understand the maximum penalty that you face for this charge?
So judges who become involved in enforcement of
Mr.
your
Mloud,
statutes.
I have other matters. Mr. Mloud,
Involved agency. What's that?
you know, I understand you want to object to things and you're going to be allowed to object to things. Okay.
Sure.
But we have to do things one step at a time. And I do have other cases today. I'm not going to entertain this for like a whole hour. I've got other cases going on. If you want to dig in your heels and just make this real complicated or real difficult, we could do that. And I can hold you in contempt and you'll go back to a jail cell for a while.
No, Your
and then
Honor,
we'll
I don't wish to be held in contempt. I just wish to exercise my Sixth Amendment right.
That's fine.
And
So before I can let you under,
I can
before I
cite
can,
laws. I can cite laws that will show you that the exercise of a right can be converted into a crime. I'm trying to understand the nature and cause of the action against me. You're not clarifying enough to where I can comprehend it, as you say.
do you comprehend the maximum penalty that you would face?
I'm not answering any of those questions until you establish that this is a court of the Constitution, has jurisdiction under these jurisdictions.
I established it. I told you. You might think I'm wrong and you can appeal
There's
it.
no
to the
such
Michigan
thing as
Court
a
of Appeals.
statutory jurisdiction.
Mr. McLeod, let me make this simple for you. Do you ever watch, let me make this simple for you.
Sure.
I'm going to ask you this question one more time. One more time.
Okay.
Two things are going to happen. You are either going to answer my question, or I'm going to hold you summarily in contempt, and the court officer will bring you to a jail cell, and we'll talk about it tomorrow. You understand that?
So.
Mr.
in
McLeod,
contempt for what?
Mr. McLeod, two things are going to happen. You're going to answer my question, or you're going to jail for summary contempt for not complying with the court's request. Do you, Mr. McLeod, understand that the maximum penalty for the charge against you is 3 years in prison and or $1,000 fine?
I don't understand the charges.
Mr. McLeod is in contempt of court, taken into custody.
Really? That's it. Protecting my rights is what you said last time. Sorry.
Fucking Joe.
This isn't true. You guys are
We'll have to follow unconstitutional
You're following
orders.
unlawful orders. It's not
Not a
constitutional at
good
all.
thing.
Mr. McLeod's in contempt, he's sentenced to 1 day. Mr. McLeod, your sentence is 1 day in jail. We'll reconvene tomorrow and get you
This is about
notice.
the Constitution. I did nothing wrong except to question and exercise my rights.
But patience has limits. When simple yes or no questions go unanswered, the court must move forward. The charge itself, assaulting a police officer, is serious and can be classified as a felony, potentially carrying years in prison. A conviction could also lead to long-term consequences, such as losing certain civil rights. Rather than addressing the charge directly or working toward a resolution, he spends his time arguing points that do not apply. In the process, he ends up spending extra time in custody. While parts of the hearing are difficult to watch, there's also a sad side. These beliefs have repeatedly failed in courtrooms across the country since at least the 1990s. The legal system does not operate on personal declarations of independence from the law. It operates on established statutes and precedent. That wraps up this breakdown. What do you think about Mr. McLeod's approach? Confusion, strategy, or something else entirely? Share your thoughts, and thanks for watching.